Okay. Hello and welcome to the Federal. Tamil Nadu State Assembly on Monday passed a bill that sought to scrap the National Entrance Cum Eligibility Test or NEET and instead replace it with the earlier practice of admitting students to undergraduate program in medicine based on their performance in Class 12 examinations. The move initiated by the state government, which was described by them as in the interest of social justice, requires the approval of the President of India. Earlier, a similar move was made by ADMK in 2017, but it did not get the approval of the President. Meanwhile, in Delhi, the Union Education Secretary, Mr. Amit Khare, had said that if Tamil Nadu wishes to opt out of NEET, it must seek permission from the Supreme Court, which in August 2017 had mandated that Tamil Nadu, like the rest of the nation, must admit students to undergraduate courses based on their NEET performance. While NEET exams were conducted on Sunday earlier, a day before, a 19-year-old son of a farm laborer committed suicide because of fear of failure for the third time. Since the introduction of NEET, reportedly, 18 students have taken their lives in Tamil Nadu. India needs more doctors. We, of course, know this. The ongoing pandemic and the vicious second wave has made it more than obvious. Now, Tamil Nadu has a best track record as far as medical infrastructure and doctors are concerned. It has good ratio of doctors versus patients and has solid primary health care. All this is made possible because of the number of doctors and healthcare professionals it has been producing over the years. I mean, the same is the case, I could say, for Kerala, Karnataka, and the two other southern states. Tamil Nadu scores high on social indicators and has a political system that has pioneered and nurtured social justice over the decades. The state firmly believes that a single window test would increase rural-urban disparity, hit underprivileged masses, and accentuate disparity in educational standards in various parts of the country. On the other hand, uniformity of standards, merit, and transparency are cited as the reasons for introducing NEET. One single exam, the central government believes, will reduce the hardship of students. Therefore, in a country where states have their own standards of education, does a uniform exam like NEET violate the spirit of India's constitution? Alternatively, is an exam like NEET necessary to reduce the burden of students writing the entrance exam? So what is the way out? Is there a via media where students' interests are safeguarded while not imposing one exam for all states? The controversy is multi-layered, and therefore, in this webinar, we discuss, does NEET-Medical violate the federal spirit of India's constitution? Now, I'm joined by an eminent panel, but before I go further, I have a small announcement to make. Please bear with me. A fortnight ago, we placed our premium product, the 8th column of the Federal, behind a paywall. The website is 95% free. We are adopting the freemium model by placing only 5% of our offering on premium. Rest 95%, I reiterate, continues to be free. The premium section costs rupees 365 a year. In other words, only rupees a day. Please type in www.thefederal.com and subscribe to the section which brings you articles and ground reports that you would rarely find in other publications. Now, after saying this, now I'm coming back to the webinar. I welcome all the eminent panelists once again. First up, I welcome Mr. P. Wilson, Member of Parliament and Senior Advocate, Supreme Court of India. I would give a brief introduction of all the eminent panelists. Mr. Wilson is a well-known figure in the legal circles. As a law officer for Tamil Nadu State and the Center, he has handled several sensitive cases and brought victory in majority of them. He was appointed as Additional Advocate General of Tamil Nadu in 2008. Mr. Wilson has appeared as a senior advocate for DMK in a number of cases. He has initiated many public interest litigations and obtained landmark judgments. Mr. Wilson won the Marina land allocation case, where now stands a memorial for late Chief Minister Sri Karunanidhi. In 2019, Mr. Wilson was nominated to the Rajya Sabha on a DMK ticket. Welcome, Mr. Wilson. Now, I go to Dr. Tamarish Cole. Dr. Cole is a specialist in emergency medicine. He is the current president of Asian Society for Emergency Medicine. He also serves as a visiting professor at University of South Wales in UK. His area of interest are emergency care system development, clinical governance, trauma care, and pandemic response, among other things. Welcome, Dr. Tamarish. Now, Mr. Mohan V. Katarki is a senior advocate of the Supreme Court. He is well versed in federal issues as he has had a long stint in representing several states, including Karnataka, Delhi, NCR, and Punjab, in the issue of water sharing, among others. Welcome, Mr. Katarki. Now I come to Mr. Balaji Srinivasan. He's again an advocate based out of Delhi. He's passionate about his legal practice. Notable cases where he worked along with Mr. Ram Jethmalani are the Black Mini case and Sharia Bano banning triple talaq case. He is currently appearing for ex-servicemen in OROP, one rank, one pension case. He was a standing counsel for the state of Nagaland until recently, Additional Advocate General, Government of Tamil Nadu in Supreme Court. And finally, I come to Dr. P.M. Yarni. She's a Chennai-based general practitioner of medicine. She's vocal about issues concerning the barriers to medical education through what she calls as imposition of NEET as a selection method, and also the impact on the state medical infrastructure. Moreover, she has appeared for the NEET PG recently. Therein, she would bring a rare perspective to this webinar. Now, let me just quickly tell you, the house rule is for 6 to 8 minutes, but your opening remarks, you're free to speak. This is not a typical television debate, so please feel free to make your point. After which we'll open the floor for discussion. If time permits, we could take some questions from the audience as well. Now, I invite Mr. Wilson to speak.
Thank you, Mr. Srinivasan. Good evening, one and all. Before I start, I thank Mr. S. Srinivasan, Editor-in-Chief, the Federal, for organizing this webinar and for having me in this panel. I congratulate the panelists, my brother, friend, advocate, Mr. Mohan V. Katari, Mr. Balaji Srinivasan, Dr. Tamuresh Kole, Dr. P.M. Yarini, who had joined this panel, and for having taken much interest in this topic. First of all, the question which is posed today is whether the NEET violate the federal spirit of India's constitution. So therefore, one should understand what is federalism. What do you mean by federalism? The word federalism can be understood as a governance system where the sovereignty of a state is constitutionally divided between the union and the state governments. When we talk about the federal spirit of India's constitution, one of the features of India's federalism that concerns the topic in hand is separation of powers between union and the state governments. The Constitution of India provides clear division of powers, enabling the union and the state governments to legislate laws on the allotted subjects without limiting or encroaching upon the powers and functions of one another. As you all know, the Constitution of India provides for 3 lists, namely union list, state list, and the concurrent list. The basic principle of federalism is that legislative and executive authority are partitioned with a mutual respect between the center and the state. The Constitution of India envisages the country to be a union of states. It is therefore unquestionable that states and their powers to legislate laws holds a sacred, important, and undeniable place in the functioning of various elements, especially education. In the recent landmark judgment of Supreme Court in K. Lakshminarayan versus Union of India, federalism as a constitutional mandate is crystallized. It clearly states that an Indian government has adopted a federal approach to the sharing of powers between state and center, and that there should be dual polity established between the two. The concepts of cooperative, pragmatic, and collaborative federalism envisages faithful discharge of functions that both union and state should follow constitutional principles and not encroach in the field reserved by the other. You all know that in S.R. Bomai's case, Supreme Court declared federalism to be an inherent part of the basic structure of the Constitution. In Kuldeep Naya's case, the Supreme Court held that the Constitution by nature incorporates the essence of federalism in various provisions to ensure its application. And even in recent NCT Delhi's case, Supreme Court emphasized that it is important to preserve and protect the unity and the territorial integrity of India, as it is a special feature of our constitutional federalism. Whatever be the nature of federalism present in the Indian Constitution, whether absolutely federal or quasi-federal, the fact of the matter is that federalism is a part of the basic structure of our Constitution, as every state is a constituent unit which has an exclusive legislature and executive elected and constituted by the same process as in the case of the union government. The resultant effect is that one can perceive the distinct aim to preserve and protect the unity and the territorial integrity of India. This is a special feature of our constitutional federalism. Further, the federal structure for governance, which is a part of the basic structure, recognizes the importance of fulfilling regional aspiration as a means of strengthening unity. Now let's come to the education. Education heavily depends on states for its proper implementation. As early as the Government of India Act 1935, education was declared to be a provincial subject. It was included in entry 17 list 2, which read as education, thereby making position clear that the education ought to be in the domain of the regional states, including curriculum, content, medium of instruction, and procedure of admission. Additionally, the framers of Constitution in the Constituent Assembly debate saw it fit to keep education under the state list, and that only subject of maintenance of standard of higher education was conferred to the Union. This was echoed in yet another Constituent Assembly debate, where it was mentioned that the center did not have sufficient reason to entrust education in the state list, and hence should be left to the provinces to carry out on the function of imparting education. The Constituent Assembly debate conducted on 2nd September 1949 also dwells into the center if education should be controlled by the center or should state have federal autonomy over the subject. Ultimately, the Constituent Assembly found favor in the argument that education is primarily a provincial state subject. However, the 42nd Constitutional Amendment made a fundamental alteration in the balance of power in favor of union government by shifting education from state list to concurrent list under entry 25 list 3. The crippling effect of such a blunder is felt even today in the marginalized communities all throughout the country. Some of the provisions of the 42nd Constitutional Amendment were even challenged in Minerva Mills case, and in fact, section 55 of the 42nd Constitutional Amendment was struck down by the Supreme Court because it was violating the basic feature of the Constitution. The prime question that arises for consideration in this evening webinar is whether NEET, being an exam for admission of students to medical courses, can it be scrapped by the state government, and whether the NEET violate the federal spirit of India's Constitution. My submission would be yes, NEET-Medical violates the federal spirit of Indian Constitution. The landmark judgments, why I'm saying is, the landmark judgments in Modern Dental College and Research Center, as well as Tamil Nadu Medical Officers Association, held that the state has a constitutional obligation and duty to provide good health and good medical services, and that coordination and determination of standard in institution of higher education was held to be separate and did not include admission and conducting of examination, and that admission does not fall under entry 66, list 1, and its scope is limited and specific, and that admission falls solely with the state powers. Thus, the primary duty of the state under Article 47 of the Constitution is to improve public health, and this is also echoed in entry 6 of list 2, which states that public health and sanitation, hospitals and dispensaries are under the state jurisdiction, and hence there is a direct nexus to the state's power when it comes to public health, and also a recognition that public health is a grassroots matter which only the state is fully equipped to deal with. A prime example to this is the difference between the primary health centers by the state as opposed to the national health dispensaries. regional language and the ability to communicate as a doctor is important and is something only the state has the resources to help with, as opposed to the center, which is placed in Delhi. Entry of NEET and its impact. This is also, we should also know when it entered and what is the impact on the system. Prior to NEET, the MCI mandated conduct of entrance examination for admissions in medical and dental courses. In Tamil Nadu, Dr. Kalanja, when he was a chief minister in 2006, brought an act called as Tamil Nadu Regulation of Admission in Professional Educational Institution Act 2006, which emphasized that only qualifying factor for admission ought to be the 12th standard marks obtained by the students studying in the respective boards. There was a normalization method by which the marks of all the boards were calculated and the merit was worked out, and only on the basis of the 12th standard marks the admissions was made. In fact, that act was challenged before the Madras High Court. I also appeared in that case. I was defending the central government. The act was upheld. Then even the Supreme Court has upheld that act, and therefore that act was in force till the MCI brought the regulations in 2017. I'm sorry, to amendment to the MCI Act in 2017. When did this regulation, NEET regulations came? NEET-Medical was subsequently brought in by the Medical Council of India in the year 2010 by replacing several entrance examinations that went on for about 70 years, which were conducted at state level with NEET. If I'm correct, it started from 1980 onwards. The exams were from 1980 onwards. At the onset of the introduction of NEET in 2010, in fact, at that point of time, I was an additional advocate general. I challenged on behalf of the Tamil Nadu government this NEET regulation in the Madras High Court, and the Madras High Court granted a stay of this regulations, and the stay was there, was subsisting till these matters were transferred to the Supreme Court. All the matters filed across the country challenging the NEET regulations were transferred to the Supreme Court. And you all know that Justice Altamas Kabir bench quashed this NEET regulations somewhere in 2013, if I'm not wrong. Yes, 13. And subsequently, you all know that a review application came to be filed by the MCI, and those regulations and the order was set aside, and the cases were restored to file. After that, Section 10D was introduced in the Indian Medical Act, Council Act 1956, and that's how the NEET was brought into the substantive act itself. The NEET examination, in fact, is a great keeper and ensuring that the education is only open to the elite population, whereas the less privileged are left in the dark. The quasi-federal structure of India has been gravely threatened by the implementation of NEET, as it clearly aims to blindside the states in matter of medical education and make it exclusively at the mercy of the center. The center have also consciously decided to turn a blind eye to the heartbreaking rates of suicide and mental trauma that the students go through due to the NEET-Medical examinations. The center, in its disregard for regional and state importance when it comes to medical education, has not only failed India as a diverse country, but has sacrificed on the fundamental right of to education. Right. The report of A.K. Rajan committee, the committee which was appointed by the Tamil Nadu government recently, has made the observation that the medical examination is an unfair way to recognize medical aptitude, and it inherently favors the rich sections of the society. The A.K. Rajan committee has also said that it works against the social justice. It is imperative that we ensure students from all backgrounds and social standings are able to become doctors, and the implementation of NEET by virtue of its structure disallows this. Even as recent as few days back, a 19-year-old NEET aspirant died by suicide, fearing failure in the medical entrance exam. This is a reality of the horror that NEET has created. Even before NEET, multiple entrance exams were conducted to allow students to enter medical colleges, which was also considered tough and inaccessible by many individuals belonging to the lower section of the society. And that is why I said that in 2006, when Kalanya was a chief minister, he brought this an act which eliminated written examination altogether, and admissions were made on the basis of the marks obtained in the board exams, 12th standard board exams. The government appointed one Justice Kalayarasan to find out what is the difficulty faced by the students studying in the government schools to get admissions. In fact, the introduction of NEET since 2017 has adversely impacted the admission number of government school students. Further, the admission to MBBS dropped to less than 0.1% from the government schools. And the private schools also, following the state board syllabus, saw a similar drop in MBBS admissions. The biggest gain was for the students from CBSE and ICSE schools. This clearly shows that the NEET examination is relatively easier for a student trained in CBSE over the rest. Coaching centers which were utilized by the elite and rich sections are the only section of society that has been able to take advantage of NEET examination. This is very clear that the data shows that only 48 numbers, this is very important, kindly see this data, this is data given by Kalayarasan. It shows that 48 number of students got admission in government medical college without coaching, whereas glaring 3,033 number of students got seats in government medical college by seeking the help of coaching centers. The scenario in self-financing medical colleges are no better, as while 52 numbers of students got admission without coaching in self-financing medical college, 1,598 students got with coaching. There's another thing, important thing is parental income is another factor that the center has disregarded in the implementation of NEET. Average parental income of students in the 2018-19 for 9 to 12 standard batch in government school is 46,686, whereas parental income of students in CBSE in the same data is shockingly rupees 4,77,263. With this income discrepancies, it is cruel to have a common entrance exam which will favor the rich parents, which is a solution given by the union government for this injustice faced by the government school students. Or the state governments are able to diagnose this income gap and allow for the opportunity in the medical field without the discrimination on the basis of income. Conclusion. Whether the state of Tamil Nadu can legislate laws to scrap NEET as medical education is a list 3 subject which is in a concurrent list. Yes, the state can legislate laws by obtaining the assent of the president under Article 254. Therefore, the bill has to receive the assent of the President of India in order for the NEET to be conducted in not to be conducted in Tamil Nadu. It is important we look for a socially apt and equal alternate solution like the 12th board examination, which is well-rounded and conclusive measure of merit is looked into to allow for an equal level playing field in the medical field for students and be used as admission process. Our dynamic leader, Honorable Chief Minister Mr. M.K. Stalin has made monumental efforts in ensuring that fair, equitable opportunities in the medical field is provided to not just the elite section of society, but to all who have committed towards serving the medical fraternity of the state. The recent bill passed by the Tamil Nadu Assembly to scrap NEET allows for vulnerable students to be given equal opportunity and ensure they are not discriminated against. Further, NEET is an entrance exam immersed in scams such as impersonation of students, sale of question papers, and fraud by coaching centers, which make it corrupted system. This also encourages public well-being. This can be further substantiated by the unimaginable role that the medical bravehearts have played in the recent pandemic, making it all the more important that everyone gives a fair opportunity to enter the medical community. The state is the only authority well equipped with resources, information,
I request
data
to
promote public health and well-being. I'm concluding, sir. The Indian souls rest on the federal structure that was envisaged in the Constitution, and hence meddling with it at primal core would be a cardinal mistake and a grave and unforgivable injustice to the constitutional mandate given to the state governments in maintaining public health, and hence NEET ought to be scrapped off to promote equality, justice, and fairness to all. Thank you very much, sir.
Thank you, Mr. Wilson. I think you have actually outlined everything from starting from defining the spirit of federalism to the various issues which are related to NEET. But there is one little issue. If you can quickly, I would like to go to Mr. Katarki, and if he could give an answer to this, or you want to take it later, you could. You see, I'm reminded of an article by Justice K. Chandru, which came in Hindu only 2 days ago, and which he referred to this issue which you are saying about the medical college admission, the order which you referred in your presentation, that it was under the concurrent list, and therefore the state can also enact a law and amend any central law on admission procedures. Now, he has cited that PG in-service case, I think, where it is only a regulation by Medical Council of India. Now, my question to Mr. Katarki is that, more or less, Supreme Court has, there is a now realization, or if not realization, it almost now appears that a NEET is only means of getting admission into undergraduate medical institutions, including private colleges, following the Supreme Court's categorical view that such a test alone would help maintain standards. So, Mr. Wilson seemed to argue that there is a place for union government to grant exemption. Is there a space here? Because he has mentioned a number of things. So I don't know where to begin, but since you are all expert lawyers, you can pick up and then try to answer the question.
Shall I answer?
Yes, please.
Yeah. Thank you, Mr. Srinivas. May I first thank you for inviting me to speak on this occasion. Mr. Wilson has done a brilliant job in outlining the subject from various contexts. The context in which you are requested me to speak is, what can the state do if the issue is covered by the concurrent list? The Supreme Court has also clarified way back in 2016 that the medical education is a part of the concurrent list under entry 25. Both the state and the center have the equal power to legislate on the subject. But in case the center has legislated, the central law will prevail unless the center, that is the president, has granted assent to the state law. What happened in 2016 is different again, because now we are faced with the National Medical Council Act of 2019, and which in section 14, the Medical Commission is empowered to impose the NEET, and they have accordingly imposed. Now, in these circumstances, the question arises whether the decision of the Tamil Nadu legislature to opt out of the NEET or opt out of the regulatory mechanism which the parliament has enacted under the central law is permissible or not. As I already said, in case of the concurrent matters falling in the concurrent list, both have the legislative powers, and if the president grants assent, certainly the state can opt out of the central mechanism, that is the NEET. So this is how the subject revolves under the federal system. Originally, as Mr. Wilson also pointed out, the Indian Constitution envisaged the education as a state subject. In fact, that was so even under the Government of India Act of 1935 also, as amended in 1940. So the whole structure on which the Indian federalism is based with regard to the education is that it is the responsibility of the states to regulate the medical and professional education. The amendment which was brought in the emergency in 1976 is a suspect. Right. This amendment changed or rebalanced the federal interest or the federal relation between the center and the state. The item 11, that is entry 11, which empowered the state to exclusively regulate the professional education, was deleted. And in place, they amended entry 25 of the concurrent list, where the medical education and professional educations are included. As a result, now both the parliament as well as the state legislatures have acquired equal powers to legislate, with supremacy being given to the center. Now, whether this amendment of 19 76, that is 42nd Constitutional Amendment, is constitutionally valid or not is a separate question. If it is challenged, perhaps it may get challenged in this case now. If the Tamil Nadu government persists upon opting out, whether this amendment is violative of the basic structure of the Constitution or not. In my view, this will be a tough question for the Supreme Court to answer. Hopefully, I personally feel that Supreme Court will say that it violates the basic structure because education is certainly a state subject. It was perceived to be a state subject before independence and after independence. Therefore, what was sought to be done during the emergency in 1976 should not continue. The matter should go back to the states. This is how it is. But if the amendment stays, then what are the chances of Tamil Nadu government in this situation? Will it be able to sell this bill to opt out of the NEET system? It all depends upon the attitude of the center. If center takes a attitude which it should take basically in these kind of matters to accommodate the state interest, then certainly it may grant an assent. But if it doesn't take, then nothing much can be done because then the state of Tamil Nadu will have to live with the NEET. There are challenges to the NEET, I understand. There are serious challenges. In fact, I think there are three aspects are there in this NEET, why people are opposing. Originally, it began with the Moini Jain case way back in 1919 Supreme Court when capitation system was abolished. Thereafter, in Unikrishnan case, the scheme was introduced by the Supreme Court where the admission to both private and medical and government colleges are held together by the state. And that's how the common entrance test came. Here came a question that the private colleges said that the scheme which Supreme Court has imposed in Unikrishnan case has created a system where the colleges shall lost all their power of autonomy or power to select the students. So this led to the reconsideration of the matter in TMFI case, where some sort of a autonomy or a power was given to the colleges to select the students. And this led to the creation of several or multiple tests, because later in Islamia case, Supreme Court said that power to select the student or a right to select a student of the colleges, private colleges, is not unlimited right, but they have to have a fair system where students are admitted on the basis of merit, subject to the payment of whatever the cost of the education, that is self-financing colleges, which may have more fees. Then this multiple examination led to the situation where the state was called upon to have a common entrance test. That's how Tamil Nadu also got a common entrance test in 2007. Madhya Pradesh got, so many states got, right? Now, this was challenging the Supreme Court, and in modern medical case, dental case, in 2016, this common entrance test was upheld by the Supreme Court, right? That has led to the now presently the center coming out with the NEET scheme, which was there earlier, which was struck down, and the Supreme Court later recalled. Now, anyhow, finally the Parliament has enacted the National Medical Council Act in 2019. It has sought to enforce the system of a centralized examination throughout the India. Now, the benefit of this are that one examination, one student appears, and certainly he gets admission wherever he wants based upon the mark sheet. He need not appear in dozens of exams. This certainly is a welcome step. But the problem is what happens to the students who cannot cope with the examination. The NEET examination is a standardized examination, completely different from what usually the boards, state boards, or other boards administer in the 11th and 12th standards. As a result, the students from the rural areas, students who have studied in the regional languages, students who do not have that kind of a benefit of central education or the education taken in the central board, CBSE, ICSE, or International Baccalaureate, or the Cambridge system, find it difficult to crack this exam. The student may be very good in the Karnataka board exam or Tamil Nadu board exam or any of the state board exam, because the syllabus is slightly different. When it comes to the NEET, it requires a separate training, which, as Mr. Wilson rightly pointed out, requires a coaching, requires a practice test, requires a rigorous preparation from a different angle, which the students in the rural areas might find it difficult. In fact, the evidence is coming out that they are finding it indeed difficult. So how to cure this is the question. On the one side, we need a national test. A single test does help the student, no doubt about it. But on the other side, there are regional interests. There are interests of the students in the rural areas, in the backward areas, and how to cope up with them. So one way I think, that's my personal view, is that the states can consider, which I think is permissible, that is, to give a weightage of 10% to the students who come from the rural areas. This kind of a reservation or this kind of a weightage may muster the support of the Supreme Court also, because recently Supreme Court has said so in Tamil Nadu officer's case that despite the NEET, there can be a reservation for the in-service candidates in the admission to the medical colleges. So if that is permissible, certainly I think some kind of a weightage given to cure the inequality.
We'll come to those solutions once again in the second round.
Sure.
Thank you, Mr. Kataki, for very clear outlining of the situation. So it's very interesting. Mr. Wilson said it completely violates. Mr. Katarki says it's a tough question, which is being posed before the Supreme Court. But of course, you also seem to suggest that the system of centralized examination, in some ways, you seem to suggest that actually it should continue, though the constitutionally or legally how things are going to pan out is yet to be seen. Now, I would like to take the discussion to another direction, but before that, I'm a bit tempted. Let me ask Mr. Balaji also, because he's a Supreme Court advocate. So, since we are on the legal issue, Mr. Kadarki also talked about what happens when a state like Tamil Nadu wants to opt out of a NEET system. Currently, from the assertion of Supreme Court, it appears that they really wanted to, or they really want this to go through. That's what their assertion is. And also, like it was pointed out, the admissions are now statutorily incorporated by the law which was passed in 2019 under Section 10D, I think, of the IMC. So, in this situation, what do you see? How do you perceive the situation going ahead? Because on the one hand, the state, there is an argument that it should be completely scrapped. And there is another argument that maybe there is a via media way can be found. So, Balaji.
So, good evening. I thank Mr. Srinivasan and his efficient team for inviting me for this webinar. I hope to do justice and speak meaningfully to both the federal website and federalism. In that sense, they are synonymous. My position is this. Supreme Court was misled into believing that NEET is a solution that is going to cure all the malice that ails the medical education. It was told that, look, you introduce this NEET, you're going to solve the two major problems which the medical education has, which is merit will be given preference, number two, profiteering and commercialization of the education will stop. But sadly, this has not happened. I hang my head in shame. As a society, we are unable to tell our children, please don't take your lives. It's a very, very serious issue. These are all young, bright minds which are feeling frustrated and they have nowhere to go. This is a very, very serious thing. So I pray that this webinar reaches out to those people and allays their concerns. Now let us understand what is the legal status of NEET. Supreme Court, as Mr. Wilson said, Mr. Katarki said, and as it's well known, has upheld the constitutional validity of NEET. What was challenged before the Supreme Court was it violated the fundamental rights of the educational institutions, religious minorities and linguistic minorities. It violated their rights. The Supreme Court said, no, it's not so. It is perfectly fine and it passed the muster. Federalism, which is sought to be brought in now, was never an issue which was debated there. So therefore, the competence of the parliament to legislate was not at all an issue. That is the point I emphasize. Now, as Mr. Wilson had pointed out, elsewhere Supreme Court has held federalism is the basic feature of the Constitution. Now, what does this federalism mean? It means a distribution of powers between the various organs of the state, in which case between the union and the state. I will not get into how the education moved in from state list to the central list. That is the matter which is going to be debated.
No, it's moved into concurrent list, not central list.
Sorry?
It has only moved to the concurrent list, not yet
state list to the concurrent list.
Yeah.
That's the point I was trying to. But what the Constitution and the courts have held is a union as a state is indestructible. But the parliament can change the boundaries of the state, can merge states and create more states. So that is one facet of the Constitution. So, and state has been given a status of a federal unit. So it's a quasi-federal unit in that sense. That is how the Constitution, the judicial decisions have described it. Now, this is a process of historical culmination. That is how the whole process was adjudicated, decided. Now, what did the Constitution end up creating? It created a federation which has a strong bias to the center. That is the Constitution that got created. So therefore, in the Constitution, center is more powerful than the state. The point I'm trying to make is this. If the issue is on the concurrent list, the parliament lays down the act, the state is perceived to have lost its power. I'm saying only perceived. So the NEET is also not violation of federalism, nor is the state act that is enacted by Tamil Nadu. All I'm saying is Tamil Nadu is asserting its rights within the constitutional scheme.
Yeah.
And till this issue is resolved, the medical admissions in Tamil Nadu is going to be done on this NEET mechanism. Is there a time frame to resolve this? Frankly, no. There is no time frame either given to the president or to our judiciary to resolve these issues. So, and thirdly, rejection of an earlier bill does not preclude the president from considering the issues afresh. It does not. Now, the conclusion I'm saying is this. As things stand today, NEET or the State Act is not violative of the federalism. In fact, it's a very interesting facet of federalism, where both the parties who are asserting their right on a subject in which both of them can legislate.
Okay. Thank you. Thank you very much. You have completely brought in a new angle to this. This is interesting, where you're saying that you need to see separately the 2013 judgment and the follow-up in 2016 and the issues it dealt with and now how it has become a federal issue. So there is a shift. I think it's very nice.
It's a huge paradigm shift.
Yeah. So that's very interesting. I think even Dr. Yerlan's, he has moved, he's an MLA from Chennai, and he has moved public interest litigation. And he has very strongly talked about education. They haven't referred to NEET anywhere. I will come to that. I'm now going to, Dr. Tomrish. You have heard all the legal views, the federalism, state rights, central law, the share of distribution of power between the two. But, as a practicing physician and somebody who deals with emergency cases and somebody who's been seeing in and out patients and this entire pandemic, what is your, idea of the whole matter? How do you see this? Because both sides at some level, because if you see, nobody is against, merit or transparency. But then the judgment in favor of NEET suggests that if NEET is implemented, it ensures the uniformity of standards, there is a merit, there is a transparency. But on the other hand, there is a social question as well. How do you see the whole issue from your perspective?
Thank you for inviting me in this panel. And I'm sure Dr. Yazini is also bring her perspective. So this issue which we're debating today takes me back 25 years back when I had to sit for an entrance exam. I was in 12th standard. I was in a good school. And in those days, there were state exam and there was a central exam, which was administered as per the CBSE curriculum. And then there were other autonomous institutes, which, one may wish to take. And I took both the exams in a gap of 7 days. When I sat in my state exam, I realized that I did the exam well, and I was confident that I will get into it. But when I sat into the central exam, I was not confident at all, because the curriculum was a bit different and the way the questions were put was different. And I realized that I had not scored well, and this was just in 7 days. And I expected, I did not score a good rank in the central exam, but I scored a very good rank in my state exam. And fortunately, I went to a good medical college in my state. And at the same time, because of the distribution ratio, the candidates who cleared the central exam, they also came, and we become batchmates. We studied together, we are still in touch. And I found no difference between me and them in terms of merits or the skills, and later on we all became doctors. So this was a personal experience about 25 years back, and I still see that is still valid. What we have to realize is, when we are talking of an entrance exam to medicine, it is nothing to do with medicine. It is a retrospective analysis of one which is gaining in the +2. And as we still are dealing with different curriculum, different teaching methodologies, and things like that, there is a variation which still exists. Now, if I base my exam based on one curriculum and one methodology, the candidate will have no choice but to take an extra education in terms of coaching or whatever you say, and therefore will cost money, energy, time, and stress on the candidate. Now, if we see this NEET exam right now, it is clearly, based on one particular methodology, and a due diligence probably has not happened, that how a candidate who is not able to afford the coaching, I'll say, or not have access to online education and do not have access to cell phone, but can be a good candidate to become a doctor. We are just, in a pandemic, and at least we have realized as a nation how important is a healthcare professional in which doctor plays a very important role in our country. So for once and all, we have to think in order to build our healthcare system, the workforce, how do we solve the problem? And how do we get people who really wants to serve the patients, the community, and the nation? We cannot have a bunch of people who become doctor and do not want to serve people, and are looking for greater changes in their lifestyle, or wants to do XYZ. We have certain number of people which will have that ambition, will become the great doctors and all that. But as a country, we need doctors in specialties like primary care, emergency care. Today, what are we suffering from? We have, and in COVID times, we have realized that we have very weak primary care and emergency care in this country. And who are going to serve this? We need doctors who are socially oriented. And to address that, we need people who from all sections of societies and evenly distributed in our country, who at least will serve his or her own community. From this perspective, I think there is a time which has come to rethink on the way the exam results are getting calculated, whether we need a percentage of the marks as suggested, which comes from the activities of the 10+2 study time, and give a weightage to that, so that we do not depend on one particular exam which is based on a one particular way of assessment. Because if we do that, then we will be starting favoring one particular section of the society, and that section of the people who will eventually become doctor may not be yielding the results which we all want to see. So a serious thought has to be given on how the exam has to be addressed, and what percentage of weightage it has to be. I'm not going into the legal debate that for the the expert lawyers and The judges will decide. I'm just telling my views as doctor and somebody who become a doctor as state expenses. My father was a school teacher. He could not afford to, send me to medical school if the current fees have been applied on me. So, and I'm not telling I'm as a template, but what we need to drive as a nation is to drive the philosophy that medicine as a service, as a larger impact part of the society. That if that principle is upheld, I think we'll be able to get to a solution.
Okay, thank you. So, in effect, it's interesting. You are trying to derive from your own anecdote as how you encountered all the problems, and you are dividing into two sections. The student, before he appeared in a pre-medical test, and his aptitude, and post the knowledge he acquires while being a doctor, and the way he serves the society. Now, the fact is, you are in Delhi and you are closely interacting with other physicians as well. But isn't there is a wide support? Because other than Tamil Nadu, most states are not raising an issue. They have no problem. In fact, most people think that NEET is a correct way of finding merit. And you must be receiving students who have cleared first batch of students who are now getting into PG. Do you see any difference? Do you actually see any difference in quality or the learning outcome which they have gained after getting through NEET? Is there any difference? Because you have a long experience, 25, 30 years, the kind of doctors you saw earlier and the quality of doctors now you're getting now.
So I think it's a very important question, and I'll just define medicine. Medicine is as much as arts as much as science. It is not only the scientific or the technical knowledge which matters in medicine. A good doctor is actually the doctor who feels for the patient, for the community. And as many of us experienced, once we go to the doctor we prefer, the doctor we like, the doctor we wants to get treated. Most of them are good communicator. They are sympathizer and those kind of quality. So if you ask me technically, there may not be much difference, but the difference which I am pointing out again and again is this larger outlook that the doctor or any healthcare professional for that matter has to have a larger vision of what he or she has to do as a part of the society. And if we take out that part, then there will be no difference in future between artificial intelligence and a doctor. And for this reason, there will be always need of human beings as doctors, as a healer, rather than doctor.
Yeah.
So technically may not be much difference, but the impact-wise, outlook-wise, there is a difference. The other question you asked is why only Tamil Nadu, why not the other states? There is no guarantee that the other states will not raise this in future. Tamil Nadu, as you told, is a progressive state in terms of healthcare outcomes. They have done a good work in primary care, emergency care. So they may be the first one to come. And who knows, the other states will raise the voice in future as well.
Thank you. I think Mr. Wilson may have to go, but before that, I want him to quickly listen to what Dr. Yarini has to say, because she has a very important perspective. She is cleared NEET and she cleared her MBBS exam, and now she'll be getting into PG exams. If you could just hear her, and then if you can give your views, because as you told me earlier, you want to leave early. So Dr. Yarini, can you please state your point?
Yeah, good evening, everyone. Thanks for the opportunity, Srinivasan sir. Before I start, I actually wanted to point out that other states like Kerala, Haryana, and Maharashtra, they have come forward asking for 50% reservation for in-service quota in NEET super specialty. It's not that the other states are not raising their voice; they are raising their voice, but then they are following the suit of Tamil Nadu. So the case of NEET when it comes to Tamil Nadu is very unique because the state of Tamil Nadu has embarked upon a journey wherein it wants to create a medical college in every district, to ensure efficient advanced medical care to its residents. So in addition to that, it has also envisioned a very strong referral system that is from the bottom of the pyramid to the top of the pyramid. That is a PHC, a CHC, a taluk hospital, a district hospital, a secondary and a tertiary center. And for these infrastructures to be efficient, trained human resources are very critical. In order to produce such trained human resources, the state went on to produce more and more medical colleges, state medical colleges, and in due point of time, Tamil Nadu, it's actually the state with the most number of government medical seats in UG, PG, and super specialty. And also to ensure the efficient deployment of its investment and to maintain the institutional continuity, the state brought in various policies to absorb these trained doctors into the public healthcare sector. So especially, in a way that all these PHCs or CHCs or whatever the institutions be, they are manned by trained, that is either undergraduate, postgraduate, and super specialty doctors. And also with the limited number of seats at hand, and to streamline the admission process, as the speakers before me have mentioned, that the states, they had a state entrance examinations. Tamil Nadu too had a state entrance examination for UG, PG, and super specialty. In due course of time, there was a realization that such entrance examinations were, they were highly biased, and it proved to be a barrier, especially to the first generation graduates, to the rural students, and to the economically and socially weaker sections, and specifically to the women candidates. And these candidates will neither have the accessibility and affordability to a coaching center, nor can they devote any extra year for coaching. So the state of Tamil Nadu, as mentioned by Wilson sir in 2006, they had decided to scrap the entrance examination for all the professional courses, including both the medical as well as the engineering ones. It was not just the entrance examination that was cancelled, but it also eliminated the improvement exam. So in improvement exam, if I score less mark in one subject this year, I can write the exam next year in the same subject and improve my mark. And using that mark, I can go for an admission into a medical college. This was abolished because such privileges are available only for students who can spend one more year for, before they get into the college. So whereas in case of NEET, a student can give n number of attempts to get into the medical college of his or her choice. So by eliminating these exams, it reduced the resource demand, both in terms of time and money for the aspirants of medical and the engineering colleges. So all this while the state and the broader civil society resisted NEET, we should thank the analogies to the, one can draw from the fallout of the JEE examinations, on the composition of the students in terms of gender, caste, and class. Also, it was made very clear that NEET would nullify the implementation of the policy initiatives, which Tamil Nadu had brought in to absorb the trained candidates into the public sector, and the socio-economic objectives of Tamil Nadu. This brings us to a very important question, as why the state medical colleges exist in the first place, and do the courts recognize the link between these medical colleges and the medical infrastructure? If the courts recognize the strong medical angle to how a state medical infrastructure operates, and also when we talk about the term merit, the Supreme Court really needs to redefine the term merit. Merit should not be based upon the success of an individual rather than the success of a society as a whole. For example, if my state creates a medical seat, and if an individual uses that seat to become a doctor, and let him be the All India rank 1, if he becomes a doctor and goes for a private practice, it can't be considered as a merit. Whereas the state medical seat used by maybe a middle or a last ranker, and then the individual going back to the public service and rendering the services to the citizens or residents of the state would be merit. So the social merit should be considered rather than the individual merit by the Supreme Court, because almost every incentive provided by the state is quashed by the Supreme Court, calling it non-meritorious and calling reservation as a mediocrity. And also, we should also give a very importance to the All India, as in why All India quota was created. Supreme Court realized that some of the states were not investing on improving their medical infrastructure and not creating enough seats. So instead of directing those states to create more infrastructure, they actually directed the states that actually made some progress to surrender few seats into the national pool, which the union would later allot. As we and a very important subject, actually, Balaji sir would have mentioned in one of his articles, any scheme when we actually devise, we go for a pilot program. A pilot program is usually conducted before a full-scale implementation of it to understand the gaps in the observation of the assumptions. Was a pilot program done in case of NEET? And even before NEET, when almost all the states had their own state entrance examinations, while Tamil Nadu had a different mode of entry, where did the union government choose the study the wealth of the experience from the state entrance examination and Tamil Nadu? Did it compare the outcomes of the various states to choose a better policy? Without doing any pilot program, how can a union government implement a policy all over the country? Also, we have a very important issue that almost no one speaks about is the women representation that gets affected in case of NEET. The nature of the examination, along with the coaching class ecosystem that these common entrance exams have created, has now led to a completely different reality. The reality where the examinations end up selecting the individuals based not on one's own ability, but the ability of the family to spend. So basically, these exams are nothing but one's affordability and accessibility to coaching centers and coaching materials, and not one's merit. So naturally, this affects women representation, because in India, women are often overlooked when the question of investing money on their education arises. This can be studied by studying the two institutions on either side of a single road, IIT Madras and Anna University on either side of a Sardar Vallabhbhai Patel road. The representation of women in institutions like IIT Madras and IIMs are as low as 8%, whereas it is as high as 50% in the state-run university colleges in Tamil Nadu. What is the difference? The only difference between these two institutions is the selection mechanism. The question of whether the selection is based on a system which is effectively low participation cost like that of a higher secondary examination, or a high participation cost as that of a joint entrance examination, is the difference here. And especially as Dr. Tamurish has mentioned, during the pandemic, we have realized that India is in need of a lot of number of doctors. At a point like this, when we need more doctors, do we go for an examination which filters out more doctors, or which is more inclusive and brings in doctors from various socio-economic and the gender category? We are at now crossroads to decide for the health of the health infrastructure basically in the country. And also the definition of the merit needs to be rechanged. I would like to actually conclude by putting forth three important questions that I have in my mind. Should a coaching class ecosystem which runs basically only for profit thrive just because of a failure in the policy making? Why should the state governments which took efforts to better the medical infrastructure be penalized for the progress they made? Do we need a system for the selection which has a low participation cost or which has a high participation cost? And especially with the next and the exit exam about to come, the coaching centers are going to proliferate a lot. Now, only after the completion of MBBS, I went to an entrance examination, coaching classes. But with next and exit exams, students right from the first year of the MBBS, they're going to go to the coaching centers. And moreover, these online coaching centers have already come up with plans for first year, second year, third year. It's only it is going to make the medical education only available only for the creamiest of the creamy henceforth.
Yeah, so thank you very much. Thank you for your very interesting and very different perspective. I do agree. I mean, your example comparing between two sides of the same Sardar Vallabhbhai is very interesting. This aspect really need to be focused. I think quickly, Mr. Balaji want to say something. Then I would like Mr. Vincent to give his opinion.
Madam, the points which you have made are very well taken, and they have only demonstrated to me personally that how flawed the entire system has been brought about. Legally speaking, there is this concept called the Brandis brief, which places social parameters at par with the precedents of the court. Brandis brief very briefly came about in Chicago. What they found was there was a crime against women increasing in 1990. And they found out it was happening at a particular time, that is at midnight. And they soon found out all the factories were having a shift which was ending and all the women were going back home. And that is when the crime was happening. So a regulation was introduced banning women from that particular shift timings to prevent crime. And this was shown as a fact to show that, look, it is in public interest that is being done. And there is a social issue which needs to be addressed. And that incidentally came to be upheld. So in the sense, borrowing, I know the example is wrong, but the principle may be right to say that, look, you have not tested the effect of NEET on public healthcare system, which is now crippled. If this can be demonstrated to the parliament or to the authorities, I'm sure there will be a real rethink, because ultimately everybody is in a public functionary, everybody exists in public interest.
So you're saying instead of increasing the policing, they would prevent women from getting out. The same like
But the point I'm making
maintaining a better, ensuring that there's better infrastructure.
The point I'm making is this. Today, it is admitted fact that the public healthcare infrastructure is struggling. That is because the feeder system that was set up has broken down. And that the sole reason for that is NEET.
Yeah. I got your point. Very, very valid. I would like to quickly ask Mr. Wilson. I think he may have to go, I think you were saying. But if you want to stay, I'm more than welcome. See, the thing is, you are very, you're very strongly argued your case and said that this certainly violates the federal spirit, and even the constitutionally it need to be challenged. And there is your own party member who has gone to, who raised this issue in the High Court here. There are 3 cases. This is one of the most prominent cases. But I just want to ask you, there is something which Mr. Balaji pointed out, that the NEET mechanism in the meanwhile is going to continue. And you're not just a lawyer, you're also a politician, you're a Rajya Sabha member. In the meanwhile, how do you intend to deal with the students? Because, there is no time period for this resolution to take place. You're taken up, certainly notices have been issued. The state government has also been implicated by the court. The whole process is going to take time. What happens? Because every time the exams come, the students are caught in a dilemma. How do you see this situation?
See, first of all, you were talking about Justice Chandru's article which came in Hindu. With great respect to Justice Chandru, I think he's overlooking 2 constitutional bench decisions. And his assumption is that NEET is a determination of standard and coordination of education falling under List 1 entry 66 is thoroughly misconceived. That's not correct position of law. In fact, as I said, there are 2 constitutional, I would say 3 constitutional bench decisions, which says that entrance examination will not come in this category. Entrance examination will come in the category of List 3 entry 25, wherein concurrent power is there, state government as well as union can legislate. So therefore, Justice Chandru article, that is his view. We are not accepting that.
Therefore, yes. I did, there was a caveat which I said, I'm not a legal expert, but I'm presenting his point of view, which seemed contrary to what you're saying. Yeah, okay.
And number 2 is how we handle the students. That was your second question.
Yeah.
So far as students are concerned, we have been appealing to the students. Look, we are taking earnest efforts. In fact, this has been made as a manifesto. This is one of the assurances in our manifesto, DMK manifesto. And as soon as we came to power, our Honorable Chief Minister as well as Health Minister were cautioning the students, look, we are taking all efforts. See, we want to bring an act. Any act should have some study. We should collect some materials. So therefore, we appointed Justice A.K. Rajan committee. We received so many representations that it runs even to nearly 90,000 representations representation from students community objecting for this NEET, continuation of NEET. And therefore, we felt the heat. In fact, those representations were considered by the committee, and they have given a very detailed report. In fact, one BJP member also filed a writ petition. He challenged the very constitution of the committee, and that was dismissed by the High Court. So therefore, then after the dismissal, then now it has been placed before the Assembly, and we have brought out a bill. So every effort is taken to see that this NEET is thrown away, at least from state of Tamil Nadu. So therefore, we have been appealing to the students after they committed suicide. In fact, this is the third or fourth suicide. Our Honorable Chief Minister, he has gone to public, and he has given an open appeal to all the students to refrain themselves from doing all these things, and let them wait, because we are taking it forward, and of course it has to pass through a procedure. Luckily, we have this wonderful document, Constitution, which provides a procedure called as Article 254, where we reserve the bill for the assent of the President. And of course, the ball is in the after the governor has now taken charge, and it has to pass through a procedure. So therefore, let us hope. After all, Jallikattu, you would have seen in Jallikattu, when whole of India has got one law, it was exempted in Tamil Nadu. So I still believe that we have the way, we have the Constitution permits us, and certainly why should we think that central government will not look into this issue? Let's hope for the best.
Okay. Thank you. I want to quickly ask Ms. Katakia.
I agree with Mr. Wilson that Supreme Court has clarified in modern dental case that power to conduct examination by the center does not flow from entry 66 of the state list, central list, list 1. It flows only from the entry 25 of the concurrent list. This is very clear what the Supreme Court has said in the case. May I just read out the passage? However, that would not include the conducting of examination and the admission of the student to such institutions or prescribing fee in these institutions. So while referring to entry 66 of the list 1, Supreme Court has made it very clear that it does not include power to conduct the entrance test. So power to conduct entrance test, the central government which is acquired, is it is relatable to the entry 25 of the concurrent list, under which both have the power, center and the state. Only question is, if the center has already made it, then it prevails over the whatever the state has done. And if the state wants to opt out, then it has to obtain the assent of the president. And he is right that we should not presume that the president will not assent. He may assent. He may allow the state of Tamil Nadu to opt out. If that happens, it's very good. If it doesn't happen, then the only course would be to bring a legislation in such a manner which will not conflict with the central legislation. That's what I suggested. That is to give some weightage to the rural students so that they'll be able to compete on par with the students in the urban areas. That's the way how it has to be done.
Yeah, okay. So quickly, another question. Dr. Yarni, I was thinking, there is a, you referred to this JEE, Joint Entrance Examination for IIT. They have done something. There are 4 appearances which are allowed in a year. And that seems to have, in a way, helped many students. They could improve their score, and somebody who got 23%, 24% can actually have gone up to 100%. Is that a way out? Would you consider that in the meantime as a possible solution?
No, that again. No, multiple attempts is again just a measure of privilege, right? So specifically, a low socioeconomic, a student hailing from a lower socioeconomic status, or specifically more a woman candidate won't be able to give a multiple attempt. So once they give a single attempt, if they don't get in, and the family no more can invest on it, nor can they afford to spend a year or 2 more for the coaching. So it was for this very reason that the improvement exam was cancelled in Tamil Nadu. So giving multiple attempts won't be a solution in the meanwhile. Also, with regards to the suicides, I just wanted to make a point here that in Kota, in every year, almost more than 50 suicides take place among the students to suicides. And in Andhra Pradesh, within a span of 60 days, 50 students committed suicide. So the suicides are not only, peculiar to Tamil Nadu to call the students of Tamil Nadu as incompetent. It's prevalent all over the India, but the political will of those states are not for the benefit of the students, but for the benefit of the coaching centers. So a special mention needs to be made to the state of Tamil Nadu here.
Okay, thank you. So just one more question. Who wants to take it? Mr. Kataki, I want to ask a question.
Sure.
While admitting the petition in the Madras High Court, the honorable judge made a remark. He said, what about, those students who would like to, far away states, say Northeast or somewhere, where they would like to become a medical professional, they want to be an MBBS, but they don't have the medical infrastructure facility available. So it would be, good for them if there is a centralized examination like NEET, where they can go across to another state and appear and get benefited by that.
Yeah, that's what is the purpose or the motive behind introduction of the All India quota of 15%. So that some states where the medical education facility is not available, the students from those states can take the benefit of the education wherever available. But this is a matter of policy. This can't be insisted upon unless the center makes a law. That's a different matter. Now, presently, it has made a law, and 15% is to be earmarked for the All India quota, right? That is a matter of policy. Right? There's nothing like somebody having a fundamental right to say that my state has not provided medical education, therefore, other states should open the doors for me. That's nothing like a right exists in any citizen in the country. But if the law is made, as it is now made, reserving 15%, then it's okay. That can be that is implemented and that takes care of.
Okay. Okay. Quickly, Mr. Wilson, there is one question. Please, still there? Wilson? Okay. So anyone can take Mr. Balaji or Mr. Kataki. There's one question.
Sure.
No, what happens? There is an issue which Balaji raised that the two objectives of this particular NEET was to end profiteering and commercialization. And have those objectives been met? Has the time has now come to review that and actually see what has happened to those objectives? And because it just seems to have shifted from being, individual private colleges probably profiteering, it's the coaching institute which are, the commercialization has gone to the other side.
See, as far as the commercialization of the medical education is concerned, NEET is not going to solve the problem. NEET only gives an advantage to the student to have a single window system of examination, where they, instead of appearing for multiple examination, they appear for one examination, and then based upon that, they stake their claim for admission. The commercialization is a separate aspect with regard to the private colleges. That aspect has been already addressed by the Supreme Court in TMFI case and subsequent decisions, whereunder they have already denied right of admission to these colleges, which was an important aspect. They wanted that right to sell the seats, if I can say it a little crudely, but that right has been now denied. They have been asked to take students based upon the entrance examination. Only question is whether they should conduct an entrance examination or it should be done by a state. Now that also is decided. Now it is to be conducted by the state itself, which was upheld in modern dental case. Now that has been taken over by the NEET, that is the center. That is how it is.
Okay. So
as far as actually this all problem started with the medical colleges, private managements seeking a right to admit the students. That's why I traced it back to the Unikrishnan case, which denied that right, which right was reinstated in TMFI case, but with a rider that there should be exam. And that exam became a problem because so many exams came, and to curb that multiple exam, single exam system is introduced. So that's how it is happening.
Okay. So there are two audience questions. If someone wants to quickly take it. One is, what is the possibility of success in bringing education from union list to state list in view of the case filed by Dr. Erilin MLA in High Court? Any precedents, judgments available? I think he has mentioned it, but anybody want to take it? So,
yeah, I said it depends upon how Supreme Court looks at it. In my view, personally, if you ask me, I would say that it violates the basic structure, because education was always considered to be a local subject or the state subject from the very early time the government of India was conceived in 1858, and expressly it was included in the provincial list under the Government of India Act 1935. Therefore, there was no reason in the emergency, when things were different, to amend the constitution and shift the matter from the state list to the concurrent list and make it complicated like this, what is happening, or to create a friction between the center and the state, right? So I think they should, Supreme Court, look at it in a correct perspective, and I'm sure, in my view, that if it is challenged, it will be struck down as unconstitutional, being violative of basic structure. This is my view.
Thank you. So I want to round up, only 2-3 minutes are left. If quickly each one of you could say what's your final, if there is any solution. I think the Tatarki offered one solution. One way to cure, he says, is that could be considered, you could consider 10% weightage for weaker students. That's one thing he said. Others, if you want to conclude, let's go one by one. Doctor, you want to say something? Kamarish?
Yeah, I think we, apart from the the percentage weightage and all that distribution, you also need to look into the curriculum, uniformity curriculum, and the way the education is happening. And we will probably able to find out some common areas in which the examination can be done, and still it will be uniform. Until that happens, because there are multiple education systems, and if there are bias of the study medium in the language, those things, if the technically corrected by the education experts, then we will be achieving close to an equality and equity.
Okay, thank you. Mr. Balaji?
Takeaway for me today is far more telling. It is telling, on one hand, it is suggested that there should be a uniform curriculum, thereby ensuring the standard is the same. At the same time, have a different yardstick for a person coming from the rural background. So I believe there are two competing interests here, which will have to be balanced at some point of time.
Okay, fine. There is one more question. I just take it and then I conclude. Anybody want to take, if exemption is granted to Tamil Nadu, would it mean end of NEET, as other states too could seek similar exemption?
Might happen.
Might happen.
Might happen. Because the social problem is same everywhere. The rural students are indeed facing the problem. Yeah. Some have come out, some may not come out openly. If Tamil Nadu succeeds in its efforts to opting out, it will set a precedent, and most of the states may opt out.
Okay. Now, this is a very different question, but a person called Kevin Fernando has asked this question. He says, do you think it's high time a merit quota should be changed from caste-based to economy and per capita income-based? I mean, it's a very, the question itself is very unusual. Yeah.
That's a very larger question.
Yeah.
I don't think it can be answered now.
It's slightly out of...
because the reservation in India is based upon the socio-economic backwardness, right? It's not economic backwardness alone. Now, by constitutional amendment, some 10% is introduced, which is purely based upon economic consideration. That is being challenged, whether that is permissible. Okay, so that is a different matter. As far as the original reservation is concerned, from the original part of the Constitution, Article 4 and all, that is based upon socio-economic consideration, which involves a caste being considered as a unit of assessment. Okay. So that's how the caste comes into question in assessing whether a particular section of people is socio-economically backward. Caste is taken as a unit. That's how it has come. It's not that the Supreme Court or the constitution makers tried to introduce casteism in India. They tried to cement the caste differences, hierarchy in the caste to be broken. So for that positive action that to achieve a social justice, the caste is for that limited purpose is considered.
Right. Dr. Yalini, your concluding remarks?
Yeah, definitely. So in Tamil Nadu, when we consider the PHCs, almost 97% of the PHCs are equipped with women doctors. It's one of the major reasons why the maternal mortality rate is low in Tamil Nadu. Whereas that's not the case in certain states. The needs of the states are different from each other. So, I've seen suggestions that a common syllabus once we have a common syllabus, we can have a entrance examinations like NEET. But again, even if we have a common syllabus, we'll have to depend upon the coaching centers, which again doesn't solve the problem of the NEET. So the states should be encouraged and incentivized for to improve their medical infrastructure rather than penalizing the states who have already made progress.
Thank you very much. We are completely running out of time. There are a few more questions I could have taken, but and then we'll really cross the time we have set for ourselves. So it's been a very fascinating discussion. Various points of view are presented. Mr. Wilson has very strong opinion that it violates the federal structure and therefore it should go, and they're going to take up in the court, which DMK has already done. Mr. Katarki has taken a line that it is a tough question before Supreme Court, and he also spoken about what happens to those who cannot cope with it when there is a system of centralized examination. Balaji made a very interesting point, how the whole perspective has changed, and both the physicians made very interesting point from a practical point of view. This issue is going to continue for a while because there is this 7.5 reservation which the Tamil Nadu government has made for economically. I mean, for those studying in government schools. Now that is that reservation is also under the challenge before the Madras High Court. Similarly, NEET as a requirement is also pending in the Supreme Court, and there is a public interest litigation seeking education be moved out of concurrent list and back to state list. So therefore, NEET, it appears, would remain in focus for the days to come, and there will be more such debate. I thank you, all of you, for a lively discussion and for participating in this. Thank you very much.
Thank you.
Before I sign off, I would like to remind the audience once again, please log on to www.thefederal.com and subscribe to the 8th column. Thank you. Thank you all. Good night.
Thank you. Thank you.